Hello everyone. With this business law lesson, we're going to look at an area of the law called intellectual property rights. And that's an area of the law that is changing very rapidly right now, and it includes a wide variety of topics, the most fundamental of which are things like patents and copyright, the rights of artists to their work and things like that. And clearly, as a business law student or someone going into business, you can find yourself on either side of these issues, either because you've created something, written something, invented something, and you want to protect others from taking it against your permission, which is often called piracy in common lingo, or because you would like to use something that someone has written or produced within your business. So it's important to stay on top of these issues as they develop. So the Constitution, as we've looked at, gives very broad discretion to Congress to regulate interstate commerce. Well, when it comes to artistic or intellectual property rights, a different section, a different clause of the Constitution covers this. In Article 1, Section 8, simply says that Congress has the power to promote the progress of science and useful arts by securing, for limited times, to authors and inventors the exclusive right to their respective writings and discoveries. And there's a few really interesting aspects of that. First, it's one of the few, very few, parts of the Constitution where they wrote in why they were doing it: to promote the progress of science and useful arts. There's a reason for this. Equally as interesting are the limited categories that are included. For authors and inventors, the right to their writings and discoveries. Out of this basic, very limited clause, Congress has passed a number of acts throughout the years, from the very beginning of our country right up through the current day, relating to protecting the products and artistic expressions of people. And it's been a balance. Congress and the courts in particular try to balance the right of the artist or the inventor to their work and to profit from their work with the public interests in having access to the work. It doesn't help anyone if someone invents an important product and gets a patent for it, but then no one's allowed to use it after that. So there's always been this balance and this tension between the rights of the creator of the good and the rights of people to use it. And even though this constitutional clause only initially specified inventors and authors, Congress has written legislation, and courts have expanded the meaning of that clause to include a wide variety of things, not just authors' writings, but photographs, paintings, sculptures, music, plants that have been created through genetic engineering, computer code that has been written. So what started out fairly narrow for the purpose of a public good has been expanded through court decisions and common law precedent throughout the years to include a wide variety of products and other goods. So we're going to look specifically at the most critical ones, I think, for introduction to this topic, and that is copyright, patent, and trademark. But as I said, there are many other areas of this law that now fall under this. Let's start with copyright. Copyright is the right of an author to their words. It now includes musicians to their music, artists to their creations, their products. So it's very broad. It's the one you'll probably run into the most often, even if you're not in business, even in your personal life. Gee, can I take a photo from someone and use it as an icon on my social media account? Actually, yes, you can, but we'll get to that. The basic rule is that the creator of an artistic work, and I'll say artistic meaning all of those categories of things I just talked about, has ownership rights to that work from the moment it is produced. It doesn't even have to be registered in a copyright office somewhere. The moment you create something, you have copyright ownership of it, and others can only use it by permission. That is the basic outline. And if they use it without your permission, the legal remedy is to sue them for copyright infringement, and it is a civil case, not a criminal case, meaning the state doesn't take action against the person who violated your copyright. You have to do it. Now, because we are in a global economy, and because there are now so many different ways to produce and share digital images and other artistic creations, the world is actually trying to catch up with technology. And in 2011, there was an international treaty signed called, I believe, ACTA in 2011, between the United States, the European Union, Japan, and Switzerland, that specified, that tried to harmonize the rules for copyright, but also specified that each country would establish criminal penalties for copyright violation, which is making copyright violation a little tougher. It has not been implemented yet, even though it was signed in 2011, and partly because in the U.S. and in other countries as well, there are no copyright police. If the state's going to prosecute that case, they have to have someone checking to see or investigate if copyrights have been violated. And we simply don't have the staff or the infrastructure to do that at this point. But it may happen in the future. And it does show that international treaties, which are the law of the land, may eventually eclipse what the law is within the United States alone. So, the basic rule is that authors have protection, but as I read from the Constitution, for limited times. So what are those times? Well, it's very different based on when you actually created that work. So for instance, in 1978, Congress passed new legislation giving authors the right to their work for their lifetime, plus 70 years beyond that. So that means after they pass, whoever inherits their estate and the rights to their estate, then it could be their publishing company, it could be a relative, it could be someone they sell the right to. They continue to have a right for another 70 years to that material. Prior to that, from 1922 to 1978, the rule was 95 years. Had nothing to do with the author's life. 95 years was the length of the copyright. And before that, it was 56 years. So you can see as time has gone on, the right to an author's work has increased, has extended. As a practical matter, because I just threw a lot of dates at you, if a work was produced before 1927, it is now available for you to use without anyone's permission, and that is called public domain. And the reason I say 1927 is because at that period of time, the rule was 95 years, and since this is now 2022, any copyrights that existed in 1927 or before are now extinguished, and that those goods are in the public domain. Having said that, that means you can use the original work verbatim. You can copy it. It's okay. There's no copyright problem. But if someone in the intervening years has taken that work, which is in public domain, and they've added footnotes to it, they've added some case notes, or done some research and put some end notes attached to it to further explain archaic language or something like that, that work is a new work, and that work is copyrighted. So you could use the work from the public domain, the original, but not what has been done with it. And we're going to see this topic come up again. So that's all with authors. Now, even as it gets tougher, and as these lengths of time become longer, that is counterbalanced. And remember, I said everything in this field is a balance. That is counterbalanced by something the courts have developed called a fair use doctrine, which essentially says that an author's works they're not sacrosanct. You may use author's works, or some parts of them, for certain types of uses. And the way the courts have been ruling on this is to balance 4 different factors. You don't have to meet each 4 of the factors in order to establish fair use. They look at each one of these factors and kind of make a judgment call, okay? So, the 4 factors are: 1, what is the purpose of the new use? If the new use is simply to take what someone else has written or created and replicate it exactly the same and make money off of it, you're going to have a problem. However, if your new use is transformative, and that's a word the courts will use, that is acceptable. So, for instance, a famous lawsuit in the music industry on this particular issue was Campbell versus Acuff Rose Music. And this is a case where 2 Live Crew made a parody of Roy Orbison's song Pretty Woman. And they essentially used a lot of the same musicality, some of the same words. They transformed a lot of the words and really changed the meaning of the song. And he sued them for that. They won because a parody is a transformative work. You've changed it. Even though everyone knows that you are referring to the original work, you've changed it. So everything that Weird Al Yankovic does is okay, because parodies are okay. It also applied to a case where someone took a photograph, a copyrighted photograph that a woman had taken, and they put it in the middle of this very large artistic collage where they added lots of other elements. That was considered transformative. It was not the original use for the original product, but something was changed to make it something new. That is okay under the fair use doctrine, and courts will weigh that heavily in favor of the new use and say it was not protected. So that's just the first factor. How are you using this? The second factor is the nature of the original work. If the original work are just facts or ideas, they are not protected by copyright. So for instance, if you read in an almanac somewhere that the capital of New York is Albany, and you write in a paper, the capital of New York is Albany, and I found this in an almanac, that is not copyright protected, and you have no legal issues there. Facts cannot be copyrighted, or general ideas cannot be copyrighted. It's okay to republish facts like that. And any facts that come out of the U.S. government, like the Department of Labor or the U.S. Census Department, are by law public domain. The third is the proportion of the original work being used. So how much of this author's work are you taking and using in your own work? Now, it's not just a cutoff like 50% or 10% or 20% or something like that. It's simply a factor to be weighed. So, in the case that I just mentioned, where a photograph was used as part of an artist's collage, 100% of the original artist's work was used, but the court said that was still okay. On the other hand, someone who excerpted 400 words out of a 200,000 word speech that Gerald Ford gave, that was found to be too much. So it's not an ironclad rule of, well, if you use too much of the original author's work, it's a violation of copyright. It's a balancing test of all of these three factors. And apparently in the Ford case, the passage being used was considered such an absolute critical passage, the denouement of the entire 200,000 word speech, that was copyright protected, and the person who used it should have requested copyright permission. The fourth factor that they're going to weigh is the effect on the market value of the original work. This is somewhat related to that question of was it transformative? Because Two Live Crew doing a parody version of Pretty Woman probably did not lose the original Pretty Woman song any sales. The use of that artist, who took the photograph and put it as part of a very big collage, yes, he made money on it, and that's okay, but it probably did not cost the original artist sales of the original picture. If a non-profit organization decides to, they find an article in a magazine and it's particularly pertinent to their organization and they post it on their website, that might reduce sales of the original author or artist or magazine. So even a nonprofit could get tripped up in this particular fourth prong of the test. It's based on, does the original author, original creator, get hit in the pocketbook because of what they've done? So you've got these four tests that the court is going to apply. What was the purpose of the new use? Is it transformative or just repetitive? What is the nature of the original work? Is it just facts or ideas, or was it something truly artistic and new and creative? 3, was what proportion of the original work was used? And 4, what's the effect on the market value? And it's the person claiming a copyright violation who has to prove that their sales are or will be hurt. It is, as I said, it is not a case where you have to meet all 4 tests or you have to violate one of them. This is a very different court approach. What they're saying is we're going to look at all 4 of these issues and stand back and look at the whole and decide, was this a fair use or not of this author's work? If too much of this weighs against you, then yes, it's a copyright violation. If most of this is in your favor overall, then we're going to say it's fair use. Now, as a practical matter, there are certain uses that the court constantly says this is a fair use, this is okay. Things such as a search engine. If you search for, I don't know, Robinson Crusoe, and it comes up in the search engine, and it's got a blurb from inside the book. That's not a copyright violation. That's considered a fair use. a teacher making copies of a textbook, a librarian using a poem to hand out to people in the library because they're doing a poetry reading or a poetry examination. That's considered fair use. Parody is fair use. Using information for research, for reviewing someone else's work, for critiquing someone else's work. When a book reviewer or some other academic wants to critique a work and they quote from that original work, that's considered fair use. So we've gotten to the point where authors' works are protected for longer periods of time, but that is weighed against the fact that more and more there are these opportunities for people who use those works to claim it was a fair use. And again, as a practical matter, essentially the person who quotes a short paragraph to illustrate a point or to critique or to say, Joe said X and Y, but researchers now know ABC, that's going to be considered fair use. And you've got an even stronger case if you actually cite that author and give them credit in the work you've created. So, that's a real quick overview of copyright, which is going to apply to not just the written author's words, but to any artistic creation whatsoever. Separate from that, and we'll do these much quicker, are patents, which is the other the other right that is mentioned in the Constitution. That is, a patent is for an invention, and it is only good for 14 to 20 years, depending on the nature of that invention. So, a new drug, a new machine, these are all considered inventions, and they're covered by patent and not copyright. This is a whole different direction in the law. In order for something to be eligible for a patent, it must be new, it must be not obvious. So don't come up with an idea that a million people have come up with and try to patent it. And it must have an industrial application. In other words, it's good for mass production of a particular item. If it meets those three tests, you can file for a patent with the U.S. Patent Office. The payback, of course, is that you have a right to the use of your machine or your invention, you and you alone. You can sell it, you can permit others to use it, but the right to decide what happens with that is yours for 14 to 20 years. The flip side is that in order to obtain a patent, you must divulge the information that went into making the good. So in essence, when it comes to patents for goods, the government is saying you've got a limited period during which you and you alone can profit from your work and from your research and from everything you put into it. But in the meantime, you've got to let people know how you did it. And after 14 to 20 years, depending on the patent, other people may go into competition with you. This is a really good example of the balancing of the rights. We want to encourage people to invent things and come up with new stuff, but we don't want to keep it out of the hands of the public, and we don't want to keep the price so high forever that the public doesn't have access to it. And that's one way to balance it. The third intellectual property protection I just want to look at very briefly are trademarks. Trademarks are not mentioned in the Constitution, and it's actually the United States that first began the idea, the concept of protecting an image as a trademark for your particular company. In order for a trademark to be protectable, okay, it must be a recognizable sign, design, or expression which distinguishes your product or your company from from everyone else. So you just can't have a red logo and say, I'm trademarking the color red. It's got to be distinguishable. It distinguishes your company from all others. So even though the color red in general might not be trademarkable, you all know well that the golden arches for McDonald's is in fact trademarked because it distinguishes that particular company in the eyes of the general public. You cannot trademark something that is already been trademarked or that looks an awful lot like what you want to trademark. So you can't just take one you really like and change it a tiny bit. It's got to be extremely different from all other trademarks. You cannot trademark general descriptions. So if you call something a fun toy, you can't stop everyone else in the world from calling their children's products fun toys. That's a general descriptor. It's not a particular name or distinguishing characteristic. Same thing with something like the word fragile on a box. You cannot trademark a surname. So if your name is Smith and you have Smith Company and you just want to trademark Smith Company, it's going to be hard unless you make it distinctive. Use a distinctive writing style, a distinctive logo that goes along with it. Go into business with someone else like Smith & Wesson. You can trademark that. You cannot trademark a social, political, or popular motto. So, phrases that you have all heard, Boston Strong, Made in the USA, Occupy Wall Street, and most recently, Let's Go Brandon. Those are not trademarkable. Every t-shirt manufacturer and hat manufacturer and sweatshirt manufacturer in the world can make those products with those slogans. They are not violating trademark because they are just mottos or slogans that are not connected or specific to a particular producer of a good or service. Similar to that, you cannot trademark someone's quote or a religious text. If you wanted to try and have a company that had a religious nature, let's say, and you wanted to trademark, in the beginning God created the earth or something like that, wouldn't work. You cannot trademark any religious texts or any quotes at all. So that was, again, a very quick run-through intellectual property rights. I'm going to have you examine today a case that transformed this entire area of the law in 1884. In 1884, again, using the Constitution as a guide, many people said, well, the only things that could be protected were authors' writings and inventors' inventions. Congress tried to include, through legislation, additional artistic expressions, including photographs, which were not around at the time of the Constitution's adoption, but which was coming into existence in the mid to late 1800s. So the case I'm going to have you look at, Burrow Giles versus Sauron, was the first case in American history where someone sued because they had Nikolai Sauron, took a photograph of Oscar Wilde, a very famous photograph today. It's called Oscar Wilde number 18. And he took this photo, and a lithography company, Burrow Giles, made copies of it. And so he sued for copyright infringement. Burrow Giles argued, well, pictures aren't covered under, you're not an author, this is not a written work. Went all the way to the U.S. Supreme Court, and for the first time the court had to decide this issue of how far does copyright protection extend. And in a unanimous decision that was again, kind of groundbreaking. They decided that photographs, just like any artistic expression, paintings, portraits, maps, charts, are all protected under copyright, and that the Constitution should be read broadly. And the reasoning that went into this case is all in the download that I provided for you. It's an important case for me for two reasons. Number one, it was the critical turning point in this area of the law. And number two, J. Lawrence Giles, who is the co-owner of the firm Burrow Giles that lost, was my great-great-grandfather. So, enjoy the case, enjoy the reading, and I'll see you next week.